hand the mic over to.
Would be-
Hello.
Hey, there you go.
Thank you. Well, thanks, Lloyd. And nice to see you back
see
in
you.
person. Yeah. I didn't do a lot of the Zoom. I'm not really into that. I'm more a person to person guy. But anyway, Curtis Schreiber, Mercantile Capital. I'm a private lender. So if you're looking for any capital for any of your projects, I finance everything from single family homes, pools of single family homes, apartment buildings, farmland, hotels, pretty much anything real estate. As long as I can convince myself it's a good deal for you, it's probably a good deal for me. I only lend my own money, so I'm easy to work with. You talk to the guy that is writing the check. And so big or small, I'd be happy to provide capital for any of your deals that you might come across. I'll leave my business cards wherever Lloyd tells me to put them, I'll leave some business cards out. You just went, okay, perfect. Anyway, thank you.
Also on that, yeah, we do have Representative Mike from JM Capital, where you can get a competitive bid from two of our lender sponsors here tonight. Not that I'm trying to any competition, but they're both good supporters
No,
of our
Curtis,
organization.
Thank you, great, thanks. So yeah, Curtis is local, so he, if there's any deals that you have that you want to stay local, Curtis is definitely a person to go to. My name is Michael Casey, I'm with JM Capital, I am out of Dallas, a lot of you have met, and you've asked me, the first question was, are you from here? No, I'm from Dallas, Texas, but it's okay, if you don't like it with somebody who's out of state, Curtis is right there, so. I've been in this industry of the mortgage side for, I don't know, years, 10, 12 years, and on the traditional side, and that side of the business really isn't fun to me. And then I discovered hard money and private money, and I discovered helping investors win, and that's really what I'm here to do, is help investors win. Whether or not it's cashing out your investment property so you get a cash offer, deal one on your next purchase, or whether or not it's a rehab, whatever it is. This is why I'm in the industry, is to help investors win, and that's why I'm here. So, again, it's Michael with JM Capital. My cards will be right over here, and if I haven't met you already, I hope to meet you in the future. I will be here on a monthly basis, so thanks so much.
Okay, yeah, and I asked him to stick around to after Kathy's speech, talk, he's gonna be around, you can talk with him some more. Okay, anybody else? Got anything for sale? Looking for something to buy? Looking at St. Charles, okay, what are you looking for? Where did Mike go?
Who needs?
Yeah, thank you, Larry, can you bring it up? Yeah, good one.
Oh, my.
So you're looking for a single family, multifamily, yeah. Right there. Yeah, Mike's not on. Yeah. No.
Anything in St. Charles.
Okay, yell out your phone number. What's a good contact?
That works.
There it is.
314-369-9324.
Okay, anything in St. Charles? 6301, 6303. Yeah, okay. Okay. Yeah, Kira.
A family that is looking for a 4-bedroom, 2-bath house. They prefer Florissant, but they are open to other areas with good schools. It's a father, mother, college-age daughter, and 4 children.
Okay.
My number is 314-836-3797. They are my tenants, but they have outgrown the house. And they pay the rent, and they take care of the property.
Okay, so opportunity to get a reference for a good tenant for you, for a house in Florissant. Yeah, I get that problem too. I usually lose my best tenants to, they end up buying a house. Or, I haven't had too many of them that are outgrown. Because I got some pretty big houses. Yeah, they're looking to rent. I understand. Yeah, they're looking to rent. So, yep. Okay. Anybody else?
If nobody else has anything, I'll go.
Sure, go ahead.
Okay. Hey, everybody. My name's Laura Linnington. Good to see you all in person again. You guys are beautiful. You look good on Zoom too, but I like this better, okay? And hello in Zoom land to everybody who's not with us. Guys, I'm a wholesaler. I spend the majority of my time working on wholesale deals. And I didn't used to think that meant a lot to a room of people like this unless you were buying. But what I have learned about this group is that I can help many of you with properties that you are looking to sell. I started doing some presentations for this group maybe a couple of years ago, and I just started getting phone calls from some of you who were looking to get out of a situation with a particular property. And I've had a lot of success with a lot of people. I've done multiple deals with multiple people from this group. And I just want to make sure all of you know about me. I like to help people with properties that are in not as great of condition. Maybe it's not ready for the MLS or the market in that way. I have a lot of investor buyers, and I know a lot of creative ways to help you get rid of your property if you're not looking to use a real estate agent. P.S. I'm also a real estate agent, but that's not my pitch tonight. So I just want to make sure you all know who I am, know what I look like. Please come and see me. I'd love to give you my card. I'd love to talk with you about any real estate issues that you're having, because if I can't help you, I could very well know someone who can. And that's what I've got for tonight. I also have 3 properties for sale. They're in 63118. If you are a 63118 buyer and you would like to learn more about them, just come and find me and I'll make sure we connect. Okay. Thank you.
Okay, thank you, Laura. Okay, anybody else going on? Oh, David, okay, David Randall's got something.
Give it a minute. There we go. So anybody in the room that comes across a homeowner that is in a foreclosure or a short sale situation, give me the lead. I'll pay you $2,000 at closing. So I love short sales. I make a lot of money. I'm so good at them. I'll pay you $2,000 at closing for your short sale lead. Okay. Now, if you know how to do short sales, then keep it yourself. But don't turn it down. Don't go, oh, I can't do anything with it. You're all upset. You had an agreed price with the homeowner and find out they owe too much, right? And so then normal wholesalers walk away from that. So don't bring it to me. I've always paid people $2,000 that have known me for their leads. The moratorium on mortgages ended July 31st. In August, foreclosures increased 27% in 1 month alone. So be on the lookout and bring them to David Randolph, okay, at 636-685-2990, or come get a card from me, after the meeting. Thank you very much.
Okay, thank you. All righty, I think it's about time here to bring our main speakers on here. Kathy Davis has been a long time ally of this group, and I think it's been a mutual relationship for both of us. But tonight, and she's always been good at, she and her associates have always been good at keeping us on the right side of the law when it comes to dealing with landlord-tenant relationships. So tonight we're privileged to have both Kathy Davis and Chris Basler from the Davis Travaglini LLC.
Hey guys, I got to echo what Laura said. It's so great to see everybody in person. I'm happy for the people who are here on Zoom too. Don't get me wrong.
Hello.
But it's really nice to be
There's
back
sound
in
in
the
this
same room with you
video.
all again. How are y'all doing? Everybody's good? Okay, good. So I was at this event before
Oh,
this
okay.
tonight, because we don't have anything for a year and a half and then we're double booked, right? I was down at Ballpark Village. There's a group I belong to called Commercial Real Estate Women. If
All right, I'll let you go.
Great group. I would totally recommend it. But we were getting like presentation by some guy from the Cardinals about Ballpark Village and everything. It was kind of cool. And there was a friend of mine there, John Schaefer. He's one of the owners of St. Louis Lateral, he's a lawyer. And we were talking about how business is and that kind of thing. And he was telling me how he's slammed with commercial title orders. And I told him where I was coming tonight. And I said, talk about the eviction moratoriums and that kind of thing. And he said, well, aren't those over? And I said, it's like that movie where the hand keeps coming out of the grave and, you know, these moratoriums seem to pop back up when you least expect it, just when you think you've kind of gotten out of the woods. That being said, I think the money that people have gotten with through the rental assistance program, you know, millions of dollars just in our area, has had some effect, because I've been saying this for months. You know, everyone talks about the tsunami of evictions and all this stuff that's going to happen now. That's not really happening. You know, most tenants kept paying their rent. Maybe they got enhanced unemployment or stimulus money or, you know, childcare tax credit, I don't know what all. Some of them that needed help successfully applied for rental assistance. And hopefully you got paid on that. I had someone who came to me before the meeting who said she had had several tenants, you know, get paid through that. I feel like that was one of those things that we wanted to help everyone with, but it was really a moving target. It seemed like every time we turned around, there was a new program, a new agency, a new way to do it, new requirements for landlords. And so it was hard for us to give advice about whether it was a good deal or not, or you should do it. Initially, I think a lot of the offers that landlords were getting involved for giving part of the rent, agreeing not to evict for some unreasonable period of time, that kind of thing. Then it got more realistic. One of the things that was really a problem in these programs, and I feel like this is something that I've been, you know, kind of complaining about for since January anyway, was the inability of local governments to get their programs up and running, or to have any kind of reasonable way that landlords and tenants could apply for assistance. And I think most programs required participation by both the landlord and the tenant in the application process. And I think most programs would disperse the money to the landlord because, you know, they did some dumb things, but they weren't that stupid. And that was, you know, how it was supposed to work. But, you know, I kept telling this to reporters in July. St. Louis County had given away less than $3 million of the $30 million it received for the stimulus money, the $30 million that was awarded at the end of December. And I still think that they have given away less than half of that money. And they don't have very much time left to do that. They had a large dollar amount of applications that were denied. The last time I looked, it was over $8 million worth of rental assistance that was applied for that was denied. I don't have any good statistics on why those applications were denied. I think a lot of it was the tenants didn't follow through, couldn't cough up with the paperwork, or to a lesser extent, I think, just weren't eligible. We, as you know, we do a lot of evictions, and we would tell people when they would come on Zoom court, the judge would send us into a little breakout room to try to talk to them, and we would say, have you applied for the rental assistance? Many of them, I mean, they're engaged somewhat because they're showing up for remote court, but they hadn't applied. In St. Louis County, and I think in the city, information was going out with the summonses, right, about how to apply? For a time. Yeah, so they had that information, or they wouldn't have known about court, all in a packet, and they weren't applying. Or they would say, you know, it's court day, oh, I applied yesterday. Well, you owe 4 months of rent, why didn't you apply before now? Chris has one. I'm going to let him talk briefly for a second to tell you about the one he was telling me about today, where, and this actually might be some mixed case, where they just keep applying and not following through. Oh, that might have been mixed case. That another attorney came in and told me, you know, EHOC attorney is, gonna sue us and do all this stuff because we won't participate in the rental assistance. But this tenant keeps saying they're gonna apply and they don't follow through. So how many people got rental assistance? In the process? City or county? St. Louis County, St. Louis City? Oh, St. Charles. We don't hear a lot about St. Charles. Yeah. Well, I wish you all well with that. I know some landlords have gotten significant sums of money. I believe that right now in St. Louis County, they're paying up to a year of past due and 3 months in advance. Do you know what they're doing in the city?
It's the same thing, though. I think the 3 months might be limited. I believe they can't get more than a year, but there's a lot of money out there. So if you've got any tenants that are behind, or at least starting to fall behind, you should really start talking about applying. I know I've got clients who almost told tenants, don't pay your rent next month until they can get 3 months ahead.
Yeah.
So there's a lot of money out there to be got, particularly if you get tenants that are behind.
Personally, again, I think St. Louis County is going to have to return some of the 30 million that they got. And my understanding is that there's more money in a subsequent bill that's still yet to come. But the other thing that's going on now is, I don't pretend to know where the COVID epidemic is going, but there's a lot of jobs. Someone can get vaccinated and someone can get a job. That is all possible now. Maybe that was not possible a year ago. Couldn't get vaccinated a year ago. Maybe you didn't feel like you could work, or the places that you would work were shut down or not hiring because of the pre-vaccination COVID part. But now you can do all that. I mean, I have literally had people, what's going on now is the dockets are still remote. This is a huge pain in the county. In the city, Chris's judge allows Chris to come in person, and some people just wander into the courthouse. So we kind of double team it, where Chris is at the courthouse talking to the in-person people, and I'm at the office talking to the remote people. Not very successfully with the city people, I have to admit, but when we do better in the county. But for when they get set for trial, it's an in-person trial in the city too, right? In Jefferson and St. Charles, it's always been in-person trials. Apparently, they didn't have the virus down there. So Chris, my brave son-in-law, has been the attorney going to Jefferson and St. Charles pretty much the whole time in person, with varying degrees of mask or no mask rules. Comes and goes. So people have to show up in person for a trial. In the county, our judge will let us take our masks off for the trial if everybody's been vaccinated. So I'll ask the defendants, tenants who have showed up for court, are you vaccinated? Because if you are, we can take our masks off. And a lot of them haven't even gotten vaccinated. But then they tell me they're afraid to work. Well, as long as people are paying enhanced unemployment, stimulus money, and rental assistance, it might be smarter for them not to work. This might be more beneficial financially. I don't know, and I'm not really sure how we get out of this long term. I've had some conversations with our new presiding judge in the county and some other personnel in the court, and they would like to get back to in-person court, but nobody is really sure how to transition to that. We are starting to see some jury trials. This won't apply to most evictions, but it can apply to unlawful detainers and ejectments. I've got one next week, but let me tell you what's gone on with that to see what kind of a fix we're in. Most of the time, if I have a case where they can get a jury trial request and it's granted because it's that kind of case, once I get on the eve of the jury trial, the other side will cave in and settle with me. But I have to have that leverage of, we're going to trial tomorrow and they're going to have to do all this work. And I'm not talking about the tenants here, I'm talking about the other lawyers. Then all of a sudden the settlement offer gets, batted back and forth and we end up working it out. During the main parts of the epidemic, the most severe parts, there were no jury trials at all. The Constitution gives a right to a speedy trial with respect to a criminal case, particularly for someone who's confined. And that's fair enough. If you are charged with a crime and you think you're not guilty, and you're confined in jail until your trial, you should be able to have that speedy trial. I think we all agree with that, but they didn't have any at all. So then when they started trying to have them again, it was just for the criminal cases at first. And here you have the problem where in a typical week, in the before times, and hopefully again in the future, they'd summons 600 jurors to the courthouse and keep them all in a big room. And then they give you a number and they do this and they do that, and they call you out in groups of roughly between 30 and 60, depending on what kind of case it is. And you go up to a courtroom and attorneys would question you and a jury would get picked. Well, obviously they haven't been able to have 600 people in the jury room right now. Even though the jury rooms are big, you know, the one in the county is actually fairly nice. If you ever get called for jury duty, by the way, get there early and sit by your plug, because and bring a charger. You're gonna wanna be able to keep your stuff plugged in because it's really boring. We can't do that now. So they've had to use a minimum of 3 courtrooms every time they bring a jury in to keep everybody separated enough. So this means that not every judge can do a jury trial. And it also means, because of not being able to have 600 people in the jury room, that they can't summons enough jurors to have a lot of trials. So both the city and the county have been running at about 2 criminal jury trials a week. They have a couple of backups, because criminal is just like civil in the sense that when it gets to be the trial time, all of a sudden someone decides they're going to plead out, or the prosecutor decides they're going to make an offer of credit for time served, or, you know, that kind of thing, and the case goes away. So they have 2 cases assigned out a week plus a couple of backups. So I actually have a civil jury trial and an ejectment, which is a fancy kind of eviction, for next Monday. And I'm happy about this. I'm happy for my client. I'm not sure I'm going to get a good offer from this particular defendant and lawyer. And then I'm starting to think today, what am I going to do with this jury? Is the judge going to make us wear masks? Masks are generally the rule in court. If we don't have to wear masks, or if we have to wear masks, I figure either way, the jury's probably going to be split down the middle. Half of them are going to be mad if we're not wearing a mask, and half of them are going to be mad if we are, right? Nobody is in agreement on this issue. And I don't think I'm going to draw a jury that thinks unanimously one way or another. If we have to wear masks, which I think is probable that we're going to have to do, the jury's not going to be happy sitting there wearing masks all day. So I better be prepared to do this quickly. And I'm not going to be happy. I'm so happy tonight that I don't have to wear a mask for you guys. Thank you. And I'm not going to be happy having to talk to my jury with a mask on. Remote court has been difficult, and we've realized doing remote court how much we rely on being in person and on body language. And then with masks, we realize how much we're missing with facial expressions and that kind of thing. So this is tough for everybody. It's really tough for us eviction lawyers. I know you feel very sorry for us. We'll be passing the hat. We still managed to be busy, although maybe not as lucratively busy for the past year and a half. And a highlight has been for me coming on most Fridays to your Zoom calls and saying hi and giving you our latest update of the labyrinthine process of eviction moratoriums and that kind of thing as we've gone along. I think you kind of know where we are right now. I want to let Chris chime in. I'm not sure, Chris, because I didn't get to ask you today if there's any news on the board of aldermen in the city passing an eviction moratorium. And if you could just give a brief update on what's going on in your county.
I've been chatting with
To answer your first question, I've
David.
only heard rumors. I've talked with attorneys. We've seen a draft of an ordinance in the city. It's very
Maybe we could
similar
do
to
it
what
next
St. Louis County has done. with
Because
very
he says he's
similar.
gonna
CDC
I
has
said,
done
"I'm
requiring a certain level
Mhm.
of action or participation with the tenant, but not a
I think
whole
that's
lot,
something
to be
you need to set up. Just do
We'll
it.
see. My belief is that the city's waiting to see if the county gets sued and how it works out before.
Yeah, me too.
before they move it forward.
Mhm.
As for the rest of it, you come to St. Charles, Jefferson County,
We need.
anywhere else, you pretty much do whatever you want. Like one list, right? So we're pretty much full board there. So that's something we're using your own lawsuit. You can go in, like, well, there's nothing stopping you. There's nothing stopping you move forward. That being said, in every other St. Louis City, St. Louis County, you could still file cases. I get a lot of phone calls, people going, I thought I couldn't file a case. And that's never been the case. We've always been allowed access to the court. The issue has always been, can we put them out if they basically call your bluff and don't pay anything? And that's thankfully going better now, but most of what we're doing is getting people in the court, getting their attention, giving them the information to apply for rental assistance. And particularly in St. Louis City, the money is coming out fairly quickly in comparison to other places. So if you're holding on to tenants, if you're thinking, oh, I can't do anything, or they're just ignoring me, get them into court and all of a sudden they pay attention pretty quick. Or they just take their head in the sand and you can actually get them out. So that's, pretty much, that goes on. Yeah.
So they are getting possession away?
Yes, we've always been able to get judgments saying you get possession, but as of a few weeks ago, the sheriff's been moving. It's slow. What I'm being told from the sheriff is that in the city, and that's where I deal with mainly, that they were supposed to get extra sheriffs to help them do evictions. But Tashara has told them no, because she wants them to go as slow as possible.
Okay,
So so they're only doing 6 a day now in the city, where they were supposed to be doing 3 times that many. But because of that, it's gonna take, I dropped off 7 or 8 today, and I don't expect to get the sheriff out there for 3-4 weeks, just based upon how backed up they are initially. I was told a couple weeks ago by the sheriff that about 300 backlog. Now, not all, but a lot of those people probably got rental assistance or have moved out, so a lot of what they're doing is weeding through. But to answer your question, yes, it's a lot slower now, but there's nothing preventing you from taking your property back. And for the long term, I don't see anything really stepping in and changing that. I saw today that Cory Bush and a few other congressmen were trying to put something through Congress of preventing it. I just can't see the Senate doing anything like that. It's going to be too much of a mess. So I think overall things are slowly getting back to normal. But of course, as Kathy said, we can't predict how things go. I tell everybody, I don't know when the Epsilon variant comes around and we all end up being locked in our homes again, what's going to happen. So, but things are, the light appears to be at the end of the tunnel and getting bigger. And there is a chance, if you've had tenants leave, I've heard from some of these agencies I keep in contact with, that down the line, when they're trying to get rid of all this money, there may be money out there for you as a landlord to get compensated. I've got no promises, but compensated for tenants, as long as you get the tenant to still kind of from the grave cooperate with you, possibly compensate you for this after they've already left. So there may be some of that, but they're still, I've been told they will call me when that happens, because I've got a number of cases where, I'm trying to get money and people are still looking to participate. Yeah.
If you already have judgments, which really occurs or COVID or that long,
Okay, so if I'm understanding your question, so you got a judgment before COVID, I assume it hasn't been paid off. The tenant is the tenant still in the property? And you want to know if you can execute on it. I would say the short answer is yes. The longer answer is how you go about doing it depends on the county you're in. St. Louis City has a rule that says if it's over 120 days old, a judgment that is, I have to file a motion with the judge and get the judge to approve it. They did that because they caught a few landlords who were using old judgments that had been paid off to evict people. And so they put that rule in. And but yes, it means, but if you have it on yourself, you do have to get in front of the original judge who did that, or at least the same division, because your judge has probably changed since then. And you want to make sure you show up with a ledger showing, okay, this is how much is paid since then. And if it's nothing, that's an easy one. But yes, if it's not been paid off, there's no time limit. Outside, technically 10 years hypothetically, but and I don't believe the county has any such rule. In Jefferson and St. Charles, you can do whatever you want. That's generally the rule out there. Yeah, they can be applied to judgments. Yeah, if your tenant's willing to play ball, they may at that age, if they owe more than a year, you may not get 100%, but you'll get up to a year's worth of rent if the tenant qualifies and participates. I have clients get $10,000-$12,000 from these rental assistance programs.
That's happened in the county as well. that we've had some clients who have successfully gotten large chunks of back rent. And, you know, the city, Chris is correct, the city was doing much better than the county at efficiently giving away the money. There was an outfit there called what, Horizon Housing Development that was coming to court and working with the tenants and working with the attorneys, working with Chris and getting rent paid much more efficiently. Did anybody ever think that I was going to say the city was more efficient running better than the county? It was happening here. It was amazing. The county was a dumpster fire. I mean, it was just ridiculous. And all the county could think of to do was, well, let's have another eviction moratorium. Why don't you fix your freaking program? Is what I would be saying, frankly. And it was hard to convince them to do that. It was hard to convince the tenant advocates. I was on these monthly meetings that would make Christine act like her hair was on fire, run screaming from the room. And I could get Chris by the reason of the fact that his children are my grandchildren and I give them a lot of things and spoil them. I could talk him into getting on these meetings with me from time to time, but you know, it was like the same thing. All these tenant lawyers and the other landlord lawyers all dropped out. They couldn't take it anymore. And these tenant lawyers were all just like, oh, the poor tenants, they're not paying. And we're like, they're making more money than we are. You know, as one friend of mine said, well, if you could get double your income to stay home, wouldn't you do it? I thought for like a nanosecond. Well, yeah, I would. I mean, I love my job, but to double my money and not have to do work, sure. I just read on my phone while I was waiting for the meeting to start tonight, I just read in the city, you know, because the city's not always good. They have a big crime problem. They have a horrible problem downtown. And someone needs to call up the landlord for that Rain nightclub and tell them to have their lawyer call me because I can tell them how to get them out faster than what they're doing. But I just read on my phone an article that all these groups, and it's the same groups that we were dealing with, these tenant lawyers, it's the same groups, Arch City and EHOC and all these guys, are now criticizing Tashara because she's saying she wants to put more police downtown because people are getting shot right and left. You know, oh no, that's horrible to give more police. Well, I was down at the thing at Ballpark Village tonight, and it's very successful and everything, but I'm thinking people are not going to want to keep moving down here and ordering, you know, renting space in here and that kind of thing if they're going to get their windows shot out. I have friends who are in that building, lawyers who are in that building that on Market that got the windows shot out the other night. I mean, I guarantee you the managing partners of that law firm are looking at space in Clayton. I guarantee you that. Of course, we're in Brentwood where it's very peaceful. Anytime you want, y'all can come see us. Okay, so before we get to more questions, someone was passing around a box for everybody to put their name in or a card. Has everybody had a chance to have there something in that box? I want to make sure that everybody gets in that box. Write your name down on a piece of paper. It's real easy because we're just going to do it here. You don't have to have anything formal. And we're going to draw in a minute because I have my Good Redbird Club tickets for October 1st. It's a night game, the last weekend of baseball versus the Cubs. And they're nice seats. They're not quite under the overhang, but you can go inside if it's raining or hot or cold or whatever. There's a real bar. And because it's the Redbird Club, they only let those ticket holders go in that inside space. So it's not as crowded as the regular parts of the ballpark. So if you're concerned about being in a big crowd, this is a better option. I don't need a phone number or anything, just names, because we're just going to draw it right now in a few minutes. Okay, so who has questions? Yeah.
So we had, about 2 years ago, we did some improvements to a tenant's house.
I was going to say, how do you improve a tenant?
Sorry.
We would like to have those tips.
So
Yeah.
did some education. No, so
Yeah.
We did the improvements and we put in a new lease and said, the lease is gonna be $100 more, but because of the improvements, the tenant said, you bet. Signed the lease, and that was in February, and it was gonna take effect in April of 2020. And then we got to, April, and he's like, I don't feel comfortable. Can I keep paying the same rent now? So we let him pay $100 less, just while COVID was happening and everything. And when it got to the new lease, a year later, we finally said, you gotta do something. And he's like, all right, so you paid the extra $100, but we're, $1,200 short then for the year, at least on paper and stuff. And he agreed to it. And I said, if you can at least apply to the program that the county's putting out here on the website, then we know that you're moving in the right direction. He may or may not have, we don't know. Is there a better way for us to move forward and try to get that?
Well, one thing that I think we learned about the county is that if they applied for the county ERAP program, they would get an application number. And once we had the application number and their name and date of birth, was that all we needed, or the social too? Maybe the social too. Christine does that. We were able to verify if they had applied or not. Yeah, I would give them I think that maybe the first deadline might be October 3rd to apply for that money. I would give them a hard deadline to go apply for it and come back to you with an application number. One of the things that was going on early in that program that was very frustrating was the tenants were applying. And I believe that some of them were applying and they just weren't getting any kind of back information at all. Or they were being told, well, your landlord has to send this stuff in, but nobody was contacting the landlord or giving the landlord a portal to submit the documents, or, that kind of thing. Some of the things that were said and done to me were very offensive, but the way they were so suspicious of the landlords. I had someone say, well, we have to have their W-9 so they won't cheat on their taxes. I'm thinking, why do you think they're going to cheat on their taxes? They're not the one who's not living up to the terms of their contract here. That's the tenant who's doing that, not my people. So I would try to, enforce that in that way. You may have altered the contract by your lease from last year by conduct by allowing them to pay less, but it's not a bad idea to just apply the amounts, to the oldest amount due, so that you show a balance of $1,200 now and see if they can get that help for that. It sounds like his payment of lesser rent was due to COVID. I feel like another thing that's kind of a moving target or difficult to understand is when the authorities in these various programs will decide this was attributable to COVID and this isn't. I just don't have a good handle of whether they have actual criteria for that, or they're making up as they go along, or what.
Yeah, I don't know either, but what your question made me think about was a good point for everybody. If you're going to cut a deal for a tenant, whether it's, hey, I'm gonna fix this window for you in exchange for rent, or you're gonna lower it by $100, it's always important to put it in writing. Because if you had said, hey, I'm gonna lower it to 11, by $100 for 12 months, but at the end of that 12 months, you're gonna pay it back at this rate or at this point, then you're able to enforce it. You would be able to take legal action. If it was an oral thing where you just said, okay, it's fine, but you always intended he was gonna pay you back, he's gonna go into court if you ever sue him and say, oh, I thought this was a forever thing. And it's very likely that without something in writing and you accepting it and not doing anything for a year, particularly COVID, you end up coming on the shore end of that. So for anybody, if you're going to cut a break or give somebody a delay, anything, agreements in writing, even if it's a text message or an email back and forth, so you can verify, it's not necessary to get, signatures in front of a notary for these things, but just something you can hang your hat on makes it easy, because, people forget, people lie, people get desperate, and will take advantage if they have to. So, you may trust these people, but writing is always good for these kind of deals. That's what I would say, to protect yourself in the future.
And it's our best evidence in court, a written document that everybody signed, saying what they say.
So in your case, I would say maybe if he's willing to admit that he owes you $1,200, then if you can get him to put something in writing that, even if you say, hey, can you pay it out over 3-4 months, you may be able to save your, claw it back if he's willing or not as clever as he should be.
When we leave the lease, I gave them three options. I said, you can leave, or you can, pay $1,300, or, extra to be able to make up for it, or else you can keep paying what, the regular price and show me evidence that you apply. So.
Yeah.
So he acknowledged it when he signed the contract.
All right, so there may be enough there. So to answer your question, yeah, I mean, you may be able to enforce it. Obviously, working with him is going to be your best, because I mean, at this stage, I'm sure even if he's back on his feet, coming up with the $1,200 or an extra $100 a month is not going to be the easiest thing for him absent the assistance. All right.
So Chris, a couple minutes ago, mentioned Corey Bush. And Corey Bush and I kind of have a history. You should know that we evicted her 3 times. And my friend Randall Reinker, who also represents landlords, also has evicted her. Christine came into my office today and said, Ben & Jerry's is making a Corey Bush ice cream flavor. And I said, what's it called? Deadbeat Tenant? And she said, no, it's not a joke, it's true. I mean, I just can't believe it.
Okay,
I'm glad I'm eating Ted Drew's. Okay. You want to reach? Oh, yeah, you want, are you, okay, I'll do it. Are you ready? Everybody got their name in? Okay. Robert McNichols. Yay! Okay.
All right, while she's giving away the goods, does anyone else have a question? They're gonna experience a general question in the future, something you've experienced in the past.
You were talking about getting those agreements in writing. What if they won't make, we agree to it over the phone, probably not an email, and you can't get anything in writing, like an agent's all something stop and start.
Right.
Sign it on your phone, and I never get it back. My question was, what if you have a hard time getting those agreements in writing, it's signed by the tenant?
Well, the one thing is, it's an agreement, so obviously the tenant wants something. And you need to condition it on, you can talk about it, oh, this sounds great, but I need to have it in writing, it needs to be in writing. This is not a deal until you give it to me in writing. And then let's say you had a deal over the phone, they're gonna do it, you send them a DocuSign, they didn't sign or refuse to sign it. I happen all the time on court, I'll send it 3 or 4 times to the tenants. Then I would suggest sending them something soon thereafter going, look, I haven't received your, in writing, I haven't received this to you. The offer, as we discussed, is going to be revoked if you don't sign it by this date. So I mean, and revoking it in writing like that shortly thereafter, before, let's say before they paid you a lesser amount, or before they've done something and you've accepted performance on the contract, on the side deal, would be enough to protect, and most likely enough to get them to play ball. That's why generally I give people, I'm on the phone with them, I'm sending them DocuSign stuff, and I'm going, all right now, so look at your phone, because we're doing this on the spot, But yeah, I mean, it just making it conditional, and then, it's like we do this with attorney to attorney, when we're calling, we're making deals over the phone. A lot of times what we'll do while we're still drawing stuff up is just, I send a quick email out to the other attorney, just to commemorate what we agreed to, or I'm going to accept this, this, and this, as long as you sign this by this date. And doing that as well would be, while you're trying to prepare documents, would be a good way to kind of memorialize it. And then if you had to go in front of a judge, you could say, look, and they say, no, we agreed to this. Well, I said, no, here's the email I sent at the time. Here's the second email where I said, where's your signature? And, and then I didn't accept it. So sticking to your guns is important too. Like, if they're going to pay partial rent and then you accept it, don't say anything for 2 months, that's going to be something where they worked out, you had a deal, you didn't say anything. So, keeping up a good record is always good, as attorneys love paper trails, and so that's important. Yes.
I have a general question. I sold the property with the section tenant back in April. And they are out of, the buyer is out of state owners. So they have like in St. Louis property management company, but I don't know. I've never met them. And they're supposed to have the Section 8 pay them directly, the rent. But the rent still came to me for 4 months, and finally, the rent paid them September. So during that time, they said, oh, have us pay some management company. I said, I don't know who you are. If you do your management duty, that rent from Section 8 should have gone to you a month ago instead of after 4 or 5 months. So what should I do? But now September, they Section 8 paid them, I guess, because no longer came to me. So the back on the 4 months rent, I got a letter from so-called management company with a PO box. I don't know if I should write in the letter or should I write to the owner, because I don't know if I write to the right person.
All right, well, what I would want to see on your behalf to make sure you're covered is something in writing from the owner, because you know who the owner is.
I don't,
Well, I mean-
it's on the deed.
Yeah, it's on the deed.
Yeah.
Something in writing from somebody from there. Now, saying this is who you need to pay it to. Now, if you wanted to double check to make sure it's legitimate, I'm assuming because you were still getting checks, you've got a somewhat relationship with Section 8 ongoing. You may be able to get Section 8 to confirm that that money should have gone to, they're sending it to this management company. And I think that would give you a little more cover as well, if both Section 8 and the owner were saying paying it to St. Louis Manager LLC.
Right, instead of I pay them directly, I don't want it, oh.
Because the people you're worried about getting in trouble with is both the owner of the property, who's that money is supposed to go to,
Right,
and Section 8.
right.
So if you get both of them to say this is who you should be paying it to, then there's no one coming after you. So that's how I would try to handle it. I try reaching out to, your contacts over at Section 8 and to the owner. I mean, because I know, I can't imagine you just pick up the phone and call the owner.
I
but if-
don't have that.
Yeah. But if the property management company's calling you saying, give us the money, then put it on them. Say, I need something in writing from the owner,
Okay.
saying this, and presumably they're not lying, particularly if you can get Section 8 to back up that this is who we're paying now. I think you're probably, pretty safe to give the money to that point.
I have another general question.
I have a response.
This is from what I've heard. I bought a Section 8 property in December. And what I was told was you probably won't get rent from Section 8 for the first month or 2 or 3 even, but it'll eventually come because it's the government, they're so slow. They're gonna probably pay the old landlord a couple months, but they're gonna take it out of your account. This is from what I've heard. They'll eventually withdraw it from your account and send it over to the new owner. So I would say, do not write anybody a check. Again, this is just what I've been told.
And it makes sense.
Yeah, let Section 8 know
they'll
you
claw
paid
back.
me. Yeah.
So I
They'll
call
take it back.
Section 8 to make sure, because they may tell you, Section 8 may tell you, don't do anything right now, we'll take it back ourselves, like he said, and then send it there. So that's probably not bad advice there too. I've seen that happen where Section 8 will claw back things from months, years when they find out they've wrongfully paid. And so they can take it back, particularly if you're getting monthly payments. Oh, yeah, they'll do it. And that's that. You say get it right. That's a good point. Like theme of the night, everything right. That would be my cover yourself in many ways as possible. But yes, Section 8 can take it, particularly if you're a regular, you have multiple tenants. I mean, I had one that I helped Kathy on where Section 8 found out a year later that a tenant had the actual Section 8 tenant had gone to prison, and her daughter was there for a full year on her, almost a full year on her lease, and didn't tell anybody the mom was in prison for the next 20 years. And I forget how Section 8 actually I think they ended up finding out when she, moved. And they took it back from my client, who unfortunately no longer managed for that owner. They had a falling out, and it was a big to-do where they took it from my client, which was going to they were property managers, so it was not their money. It was other landlords' money, owners' money that they do. So it was a big lawsuit, and Section 8 kept yelling at us, and we spent time going around, and eventually it got straightened out with my client not suffering any damages other than wasting a lot of time and a lot of yelling. But it was, section 8 can do that, but yeah, I mean, they could very well be taking it back once they realize it, and to his point, they may not realize it for months that they gave it to the wrong person, so.
There's a way to talk to them.
Yeah. All right, anybody else? Okay, so she's asking me to recap what the county's doing with evictions. This county council issued their own moratorium that I believe starts this week and only lasts currently until October the 3rd, saying that you can, if a tenant, basically it's what the CDC was, which is a tenant comes with a piece of paper that says, I've lost income and I've tried to make all my payments and I've applied for rental assistance, then you have to freeze the sheriff until October 3rd. Now, we all suspect that unless they get sued, October 3rd is not the end date of this, but that's something you're gonna have to watch out for is if your tenant's coming to you with a piece of paper, and it's probably gonna be a CDC declaration, but my understanding is that counts for the county one.
Yeah, supposedly they're gonna honor old declarations. I can tell you that we have been filing, lawsuits, we've been getting judgments, we've been filing executions. They're still being scheduled. They're not stopped across the board. Earlier, the county stopped all evictions across the board. That's not happening anymore. We have a new presiding judge now, and I've spoken with her, and she's a little skeptical about the ability of the St. Louis County Council to direct the court in what it does. And it's interesting, because it's always interesting in St. Louis, because it's so weird here, right? I feel like we should have asked those mortgage guys, if they wanted, if they're local or they're not local, where'd you go to high school, right? I mean, why is that such a thing here? But the thing about St. Louis County is the sheriff is an employee of the courts. In the city, the sheriff is a separate elected official and might feel like he has to get along with other elected officials like Mayor Jones. In the county, the sheriff is a person who reports to the judges or to the presiding judge. None of the judges like the idea that the council can tell them what to do. You remember school, high school, or maybe earlier, the 3 branches of government, right? Executive, legislative, and judicial. Judges and the judiciary in particular pride themselves on their independence from the other 2 branches of government. And no one is the boss of them, in a way you can understand all of the world by thinking about how a 3-year-old looks at it, right? But I think that they are expecting that if an eviction is stopped, that there's going to be a lawsuit filed. And it might happen, and it might be us, it might be somebody else. I've kind of given up on Eric Schmidt, he just seems kind of useless, but we very possibly with the right client, the right situation could do it. That being said, all through this time, we have been very successful in the county in getting eviction moratoriums stricken. We don't go after everyone. We know an attorney who filed 70 motions to strike at once, and the judge continued them all for months because she didn't want to hear them all at once. We cherry pick the ones that we do, and if you have someone who really needs to get out and they haven't applied for assistance or they can't prove that, we can get them out. Don't worry about the moratoriums.
St. Louis County Council and the mass mandate, they overruled Sam Page, that's still effective.
Judge Roboto struck down, has maintained the restraining order against the mask mandate, so there is no mask mandate in St. Louis County.
Yeah, I mean, they could file, she's told them if they want a mask mandate, they have to actually pass another one. And if you read what the county council did, it was kind of a bit of politicking in that they didn't really say they were passing a mask mandate. They were just saying in general, they approve of masks. So it may be some hesitancy to actually do something. And, of course, the attorney general said he's going to sue again if they try it again. So we'll have to see. I'd rather enjoy not wearing masks at the gym.
I thought they overruled Sam Page.
They did. And so the judge said that that's final and that's it. That one's over. If the county council wants to do it again, they have to, Sam Page would have to issue a new one. And then the county council would have 30 days to approve it or not. And so you know, I haven't heard, I think that ruling just came down yesterday, from Judge Roboto. And I've not heard whether or not they're gonna take up another one, but I suspect they probably will. You know, this is a lot of circling each other, posturing back and forth on both sides of this. And so, but that fight, you know, won't be over for a while. Anybody else? Sir.
Tenant police,
try to get them out, even though they're paying the rent. The city hasn't really cited it for all the trash around it. For some reason, they seem to be okay with it, so what's the chances of I just give him a letter, tell him he's gotta leave, and then if he doesn't, we gotta do something else.
All right, for anybody who didn't heard the beginning part, he has a tenant who's gone past his year lease. And once you do that, if the landlord accepts rent and the tenant is still there, that turns into a month-to-month lease. So the tenant's been on a month-to-month lease, been paying the rent, has garbage, trash in the place, he wants to know how to get them out and what's successful. You have a couple different ways. Both ways would likely be successful. There are no moratoriums, or I don't anticipate any moratoriums that would stop you from filing what's called an unlawful detainer. Now, you could go one of two ways with something like this. On a month-to-month, you have the option, just like the tenant does, of giving a month's notice and telling them they need to be out of there. And you don't even have to have a reason for doing so. You'd have to do it before the end of September to get them by the end of October. And one thing that a lot of landlords don't do is they think, no, certified mail seems to be the best way to do it. Unfortunately, even in a scenario where you can see the tenant sign for it, some judges might not give you that because the technical right way of giving a termination is to hand deliver it to the property, attempt to serve them personally. If they're not there, tape it on the door. And you have to do that before the end of the month, giving them until the end of the next month. Now, I've got some case law in my back pocket that I intend on using at the right time that says if they actually prove that they got it, it doesn't matter how you did it, but I haven't had to use it yet. I'm not trying to make a bad law at this time. But so that's option A. You could do that. If they didn't move out in November 1, you can file a lawsuit called an unlawful detainer that says, I gave them termination, they didn't move, and now I want them out, and you would be successful in that endeavor. The other option, if you want them out a little quicker and you say trash in the place, this kind of depends on how badly they're trash in the place, is terminating them for cause, meaning you're giving them a reason. You would say, instead, now I just want you out because I don't have to give you a reason. You have to say, I'm doing this because you're trashing the place. Now, the key there is you have to go in front of the judge and explain to him or her how they're trashing the place. And it has to be serious enough for them to really be upset about it. But the nice thing about that is without absent your lease staying longer, you can give as little as 10 days for the tenant to move out. Now, one thing I'll say about that is you give a tenant 10 days, you're filing a lawsuit. There's no one moving out in 10 days. Occasionally, not often, but occasionally when I do the full 30 days, full month lease, people will actually leave. Now, one thing I do suggest before, if you have some sort of working relationship with a tenant and they'll talk with you, maybe you say, look, this isn't working out. I need you to leave. And if you can get the tenant to agree to leave, and this is in the middle of a year-long lease or a month-to-month, get them to do it again, theme of the night in writing, then it makes it a lot easier, because if your tenant signs something agreeing with you that their lease is going to be terminated October 15th and they don't move out, you don't need to prove anything other than they signed it. And it makes your job a lot easier, our job a lot easier if you come to us than putting them out. And you wouldn't have to prove how bad it is. You wouldn't need pictures. All you need is a piece of paper saying this is what they signed, saying they agree to be out. And the judge wouldn't have any way of stopping it. And that's how they look at that.
We're very aware on these terminations of the end of the month, because most rent due dates are the first of the month. So if you've got, like, as we are now in the last part of September, you might want to pull the trigger on the notice of termination before the end of the month so that you don't lose another month.
Yeah, it's always the worst when someone calls me on November 1st or 2nd and goes, I have a month-to-month tenant, I want them out, and I have to tell them, well, now you got to give them almost 60 days to get out. And they go, well, I can give them 30 days. I'm like, it's not technically 30, it's a month. And so, in February, you get to save some time. But yeah, so that's always and inevitably, on October 1st, I guarantee I'll get 4 or 5 calls about people who want to put them out, and then I'll have
Commensurate with the rental due date, so you really need to do it. Right now, you have to do it by September 30th, to be effective October 31st. And the other thing is, CaseNet covered this, to be terminated after termination date, don't accept rent. So if you give them a notice before September 30th, be out by October 31st, don't take November rent. That creates an
Yeah, so I'll get you next, but I just want one more thing. I got called in last Friday at 2:30 saying, hey, I'm having trouble with this trial as a landlord who filed on his own. Can you be down in town in an hour? And I said, yeah. You mean he paid for it, but I was downtown in an hour. And I had to scramble, bluff, do a little bit of moving and shaking and give the tenant a better deal than he wanted to, because he was taking payments electronically. And when he terminated the tenant at the end of July, he didn't block or turn off the electronic payments. And so he had been accepting rent August, September, and I could see when I was talking to the tenant, her mom had a sheet of paper proving she had paid rent, and I don't think they knew what that meant. Otherwise, they wouldn't have been talking to me, but I knew what the judge would say. So we ended up cutting a deal. It wasn't what my client necessarily wanted, but it was the best deal to prevent him from having to, she's gonna get out. We had some guardrails for how she had to behave until she got out. And, but it's happened a lot with electronic payments. It's obviously easy if you see it, if you terminate the tenancy and they write you a check, send it back. Take a picture of it that you sent it back, but send it back. Don't keep it. If you had a bank account, and you didn't catch it, that they slipped into your bank account, a couple of days later, it's the biggest deal. You can always turn it back, but don't hold on to it for 2 weeks and then try to file a lawsuit and say they're still in there, because that's probably the only way you're going to lose something like that. We can get involved in one of two stages. The termination part, unless you have a Section 8 tenant or some HUD tenant, then I wouldn't say doing that termination by yourself would be a wise idea, because that's too much detail to get into, but there's a lot of steps you have to take, a lot of language you put in your termination. But the termination part, you all can do that yourself. Doesn't require an attorney. Generally, the only my clients who actually pay us to do the terminations are the ones who are out of town, or the ones who are.
No, we can do the termination for you too.
You don't have to.
You don't have to use, we charge about $150, and that includes serving the notice. So it's not that expensive to have us do it. And we will get a professionally done notice, and we will get a return of service filled out. So it will just be in very good shape if we have to take it to court. I actually terminated someone last month who was a Section 8 tenant in an elderly housing complex. I terminated for bad behavior, and my special went down and couldn't get her, so he posted it on the door. And she was so embarrassed that this notice about her bad behavior was on the door, that the moving trucks are there. So, yeah.
But to answer your question, the real, yes, we could do it, and it would avoid you being concerned you're doing it incorrectly or not writing the right thing. So that's what we can do. Or, an argument with your tenant you don't necessarily want to have, because a lot of times it is an aggression thing that people say, I don't want to deal with it. And some landlords, believe it or not, it probably is true that something with the attorney's name on it will let them know you're serious. But more importantly, particularly if you have your entity in your property in an LLC, you'll need to have an attorney when it's time to file the lawsuit after it's expired and the termination date's expired, and you need to move forward and put it out because they haven't left. You can't file until that date, even if they tell you I'm not getting out, you can have to sue me. You still have to wait until the date comes and goes before you can actually file. The date, the end of the month.
And this gentleman that Chris went down and helped out the other day, we charged him more than what we would have charged him if we'd had the case from the beginning. And he wouldn't have been in a position where we had to make a deal that wasn't that favorable, because we would have done it right and told him about not taking the rent and that kind of thing. And I want to say one more thing for those of you who use electronic payments or lockbox or that kind of thing. If the tenant pays you the rent after the termination, you're not completely hosed there. There's case law that says you can return it, but you need to return it right away.
I think you had a hand up.
Oh, I was just gonna make a comment on the initial question he had to you, that if your lease states that rent is due on the 1st, and you're trying to beat that first date, and tell them they have 30 days, don't count on getting that rent on the first,
Right,
for that last month.
right.
This is kind of,
Yeah.
just kind of
Now-
accept that as being at a loss.
And there is a way, and to his point, they're probably not gonna pay, they owe you the money for that rent, like, so September, October, he would owe you this money, and you could accept October rent. Can't accept November rent, but you could accept October, but he probably won't pay it. That's just the reality of the situation. Now, I have done a lot of times with folks where we filed rent possessions right away and terminated at the same time for the ones who owed rent or the ones who didn't pay rent the next month, figuring once we get them into court, if they're already not paying rent and mad they're gonna get terminated, then they're probably not going to call your bluff and actually pay you up. So it is a way, if you're looking to be a little bit more aggressive, to move things quicker without having to wait until November, should they choose not to pay the rent while they're in there. I've got several landlords that I do that route. I've only ever once in a decade I've been doing this, had anybody call my bluff and actually pay it, make me file the second lawsuit. So generally I can work it out with them once, they get in court and realize it.
Not that I'd be thrilled to be a Section 8 landlord, but have landlords who have Section 8 tenants been subject to all the various bleepity bleep that those who have tenants who are not Section 8 people have been?
Yeah, okay, so section 8. So how many of you guys heard me speak like 30 years ago? You're just a room full of young people. So it used to be that I was very anti-Section 8 because the housing authorities were difficult to deal with, and there were problems with Section 8, the inspections and, issues with the lease. And it seems like if you have an issue with a Section 8 tenant, you are almost certainly gonna get a tenant who's gonna know how to get represented by legal aid or, one of the tenant groups. But I can tell you that during this pandemic, for the most part, the Section 8 landlords have been getting paid. That rent has kept right on rolling in. So, there's some reasons to do that. Section 8 probably more so than other kinds of landlords were subject to the eviction moratoriums, subsidized projects and that kind of thing, pretty much, that received federal money, pretty much could not evict during the federal moratoriums for non-payment. We can still, and we have been able to evict for the behavior reasons, the trashing reasons, that kind of stuff throughout. Section 8, this is where you could do your own termination for a regular tenancy, but a Section 8 termination has to have special language in it and that kind of thing. You should at least call us. Even if you don't want to hire us, you should at least call us to talk to us about the proper way to terminate a Section 8 tenancy. It can be done. You have to do extra stuff, and you're probably going to draw a lawyer representing the tenant.
And I would say they're currently, and since the federal moratorium, the CDC moratorium didn't have a whole lot of difference between Section 8 and non-Section 8 as far as, I filed evictions against people who didn't pay their portion of Section 8. Now, I'd say most of my landlords who had Section 8 during the pandemic, even if they weren't paying their portion, didn't really want to put them out because it was guaranteed money on the portion Section 8 was paying, but we were able to get people out in Section 8, particularly once the federally backed mortgage portion of the early part expired, which was August a year ago. So yeah, there's no special category that, once they've switched over to CDC or the county moratorium, or maybe the city one that will come up, it's not going to differentiate between Section 8 and non-Section 8.
So I'm hearing from a lot of landlords that I love my apartment before the Section 8 through all this, and I'm going to do more. I think there's a lot of houses involved in inspections and recertifications and all that kind of stuff, but well.
Yeah, the biggest problem complaints I've heard is from the landlords who have, particularly in the city, slightly higher numbers. And so you have to sometimes, you don't know during the early process how much Section 8 is going to pay for your property. And so I hear a lot of landlords, I've had a couple last month ask me, well, I don't want to discriminate, but because in the city, you're not allowed to turn away Section 8. But at the same time, they've gone down the path where it takes Section 8 6 weeks to evaluate their property, and it's not what they want. Meanwhile, they've held up their property and not rented to something else. So what I've advised them to do when they move into Section 8, person who's applied, say, look, you can go down the process, but my policy is the first tenant that comes to me prospective tenant with an approved background check and the ability to pay is getting an apartment. So you better tell Section 8 to hustle up because I'm still marketing it. So that's how I would advise you to do. Even if you're going through the Section 8 inspection process, still keep marketing the property because it's possible that Section 8 might, they might say it's worth $800 a month and you think it's $1,000, and you got someone else who walked away from a month ago who was willing to pay $1,000 a month. It's something that you can do it without also discriminating against, particularly the city, because that's a protected class. So as long as you stay consistent, that's going to be the key.
The county, I don't think ever passed an ordinance like that. And I really don't think that the city's one is enforceable.
I don't think so either.
They can't make you contract with somebody against your will. But, Chris is correct. And what we're generally telling people is just don't say no Section 8 in your rental ads or, that kind of thing. Let them apply if they want, but, in this case, maybe the hare is going to beat the tortoise. The person who's fastest in with their completed application, their deposit and everything is going to get the apartment.
Yeah, and so, it's big, particularly in the city, but anywhere when you're talking about discriminatory practice, one, I don't discriminate against folks. Certainly don't put it in writing, don't answer hard questions like that. I had a client who got in trouble and paid a lot of money to EHOC for having a sign on this building that said quiet adult living. And they said that's discriminating against children, and the HUD people agreed. So if he hadn't had it in writing, he probably never gets caught with it. And he probably, he paid out a lot of money, let's put it that way. Anybody else?
Sure, I was just gonna say, if you're looking for anecdotes, we had two Section 8, and they were both paying part of their rent. The city was paying the rest of the housing authority, and both of them immediately as COVID started, they were paying 100% and have done so the whole time. No inspections, no hassle, no paperwork, like just nothing. I think I just got a notice for the first inspection that hasn't happened ever, but at least they're trying now.
Yeah, I've heard a lot of people tell me that normally Section 8 is real on the money by requiring the research and whatnot, but I had one that came to me today, and their Section 8 lease was up in March, and they still have, and they just this month got notice that the tenant had not come in and recertified, and Section 8 was holding the money until they did. So Section 8 is a little bit behind where they at.
I have a question regarding Section 8's their policies or whatever. I'm from Illinois, so I know it's Section 8 for most of it's federal, but so I'm thinking maybe the rules are still the same across state lines. But my in Illinois, and I'm real close with the officials of my housing department, Section 8, whatever, and they had told me, and I found it curious because you said you actually had evicted people that had vouchers for Section 8. And my question to you, did you know if those people that got evicted, did they lose their voucher status? Or were they just able to move on to someone else and still maintain their Section 8 voucher?
That's a really good question. And I will tell you that there are a number of different programs in Section 8. And Section 8 is a federal program,
right?
But it's administered in many cases by local governments. So St. Louis County Housing Authority, St. Louis City Housing Authority, and like St. Louis City Housing Authority can give a voucher that someone can rent in the county with. So it's very confusing, and I'm not 100% sure I can answer your question, particularly when you start talking about Illinois.
Okay.
Yeah. Yeah. And that leads me to maybe just a brief update on CaseNet. In Missouri, do y'all use CaseNet?
Yeah.
I mean, you should do other screening too. Our last presiding judge, who left to go to some program about reinventing his life at Notre Dame, Judge Burton, signed an order on his way out the door in August, basically saying that all landlord cases were going to be raised to the highest security level. So that meant that landlord cases that were filed during that time were not going to be viewable by you on CaseNet. So I said this a couple of times on the Zoom calls with you, but I wanted to remind you that CaseNet is not the only way to screen. Definitely use it. The new presiding judge Judge Mary Elizabeth Ott has revoked that order. We still think there are some cases that are kind of in limbo. Definitely use CaseNet, but don't assume that it's 100% accurate. And CaseNet is also very quirky with respect to spellings and that kind of thing. And tenants are clever and they'll figure that out, that they can spell their name differently or use their middle name or that kind of thing and not show up on CaseNet. And the other thing that I would encourage you to do with CaseNet is when you're looking at somebody's old eviction, see if you can tell if the judgment was satisfied. Because if it was satisfied, that means they paid it off. So that means at some point they were responsible. Maybe they got evicted first, or maybe the judgment came and then they got it all caught up, or that kind of thing. And we would obviously prefer to encourage tenants to do those things. So if you give them a little credit because they had a judgment but it got satisfied versus someone who had a judgment and never paid it, like Corey Bush, we would appreciate it, and your fellow landlords would appreciate it, because we want to encourage the behavior of, getting those debts paid. You got anything else?
So I think you said when we talked to you that if there was a past old judgment that we could still, the tenant could apply for the assistance, rental assistance?
As it stands today, they still have to be in the property, or
Right.
they could even be on the way out. I've got companies that Horizon in particular in the city is willing to give the back rent to the landlord and 3 months forward to the new landlord. So it's worked out great. And I've done a few of these deals where people are on their way out, even if they're gonna be leaving in the next week, they've been applying on their way out the door. But if their tenant's already out of the apartment, then no. So if they're still in there,
They're still in there.
there's no age
On their
limit.
way out.
Well, I mean, I believe it starts they had to have lost income in March of 2020, but even if it was before that, there was creative ways of you doing your accounting to apply rent that they paid post March 2020 to the back stuff. And then, they're only behind for stuff during COVID. So I'll say this, very rare have I seen anybody, a motivated tenant and a cooperating landlord that didn't get the money. And maybe if they're on Social Security, you really can't say they've lost anything. But my experience is that those doing the applications are asking questions in ways that they're telling you, or more importantly, telling the tenant the right way to answer the questions. And so I'm not telling anybody to commit, fraud in any way, but, it's a very broad and vague way to say they qualify. So I think almost, how many of us, anybody can lose a few bucks and, say they qualify for it. So I would think, yes, if being old does not change their ability.
So does a tenant have to apply?
In most of these programs, the landlord can apply, but the tenant has to cooperate, or the tenant can apply and the landlord has to cooperate. Most of the programs allow either one to be the one initiating the process, but you both have to be involved in it at some point. Now, I want to point something out. Robert McNichols just won 4 Cardinals tickets, and he's sitting by himself.
Yes, so it's old judgments don't matter. I will say there are some agencies, more agencies that are the tenants have to actually come in first. But a lot of my clients, particularly the ones who have full-time employees working for them, have switched from being property managers to being application specialists. And I mean, that's, you're really gonna, particularly for your less sophisticated tenants, you're gonna have to hold their hand through the process. You're gonna have to, did you get this in? Did you get that in? Because a lot of these times it's getting paid for, but either you'll do something wrong or they'll do something wrong. So there's a lot of fixing small things. If they don't, some of them, if they don't fix it within a couple of weeks of getting noticed, the whole process gets scrapped and you're starting over from scratch. So there is, a lot of times with tenants, there's some hand holding, but they can get it. You can get a big chunk of change for the older judgment. It won't be a problem.
So what's the website for that?
The
County.
county. Do you know the county website? I'm sorry, I do most of my stuff in the city, so I'm not giving these speeches in the county.
But if you go to the St. Louis County government website, you can find, there's a COVID relief tab, I think, and it'll take you to where it is.
Okay.
I have it.
Oh, okay, great.
Okay.
Okay, you guys, I think it's getting kind of late. You have been wonderful. Hopefully you all got our business cards. You can call us or email us if we can help you, again. And we'll still pop up on the Zooms from time to time if John and Lloyd want us. I really appreciate John and Lloyd and our sound guy from MOOLAH. Thank you.
Thank you both very much. And before we get away here, John gave me a couple of things he wants to give away. I think this is more appropriate. Where were those first-time visitors? We got a great, John put together a great resource manual, a lot of definitions of real estate, a place to keep your notes for when you come to the meeting for a year. Okay, we have one here. How about, you interested in it? Okay. Okay, and got one more copy. I saw this hand up here first. Thank you. Okay, thank you. And, oh, you want another one? Okay. Oh, boy, John's really getting generous with it. Okay, there you go. Okay, if you haven't already gone over and looked at the table, we got materials. There's some great values there. You know, we paid, people have paid thousands. I myself have paid a lot of money for things, and when I've gotten an update on them, I've donated them to the organization. So it's a great opportunity. And I tell you what, we're going to do from now until we close up here, so we don't have to pack up all those books. How about a 2-for sale? Instead of on the $5 table, if you can get two, pick up 2 books for $5. On the $10 table, pick up two pieces of thing for $5. How's that sound? Like a good deal? Appreciate it.
Does that apply to someone who already purchased?
No, you go and get more. Go back and get more. You got first choice on it. Yeah, there was probably only one of the items there. Anyway, appreciate y'all coming. We still got plenty of time here. We don't have to be out of here till 9:30, but stick around, talk with Mike over here about financing and or Curtis. Thank you all for coming. Hope to see you next month, same place, same time. Thank you.
Good question for a couple there, probably for Kathy and Chris.